Representation of council.
May my lord be pleased.
Yes.
Al Hassan is my name.
Yes.
For the plaintiff applicant.
Okay. The claimant.
Applicant.
Yes.
My lord,
Any
we have filed, there is no appearance to the defendant.
Yes.
My lord, we have filed a notice of discontinuance.
What was the case adjourned for? At least you need to lay a kind of foundation.
As course pleases. My lord, the matter was adjourned for us to file our notice of discontinuance. The last adjourned date.
When that is the case came up for hearing?
Is sorry, my lord. Sorry, my lord. The last adjourned date was slated for mention, my lord. And the parties have settled the matter.
This case came up before me on the 6th of July 2021.
Yes, my lord.
When you one rappel or voted them, you informed the court that they were filing the claimants going to file notice of discontinuance. So we accordingly adjourned the case to the 27th of July 2021 to enable the claimant file the notice of discontinuance.
As course pleases.
The case was later heard on the 8th of October. But the said notice was heard on the 8th of October when one everyone appeared, and it was a virtual sitting, and the court could not even see him, so he was not visible. So we couldn't record anything. We had to adjourn the case another date. That was 11th of November 2021.
As course pleases.
Case was, however, heard on 12th of November 2021 when parties were absent and there was no appearance. We accordingly adjourned it to 14th of January 2022.
As course pleases.
Satisfied notice of discontinuance. So, what do you want to tell the court?
Yes, my lord. We have now filed the notice of discontinuance of this matter, my lord.
Okay.
Dated 12th day of November 2021, my lord.
When did you file?
We filed today, my lord. 24th day of January 2022, my lord.
Yes. Yes.
Yes, my lord. By this notice.
Yes. It appears Mr. Hassan is having issues with the network.
My lord, by this notice,
Yes.
yes, the claimant is hereby discontinued with his matter before you, my lord. We urge you to
Adopt same.
adopt same, yes. Thank you, my lord.
Did you serve the defendant?
My lord, we have
Yes.
yes, the registry informed us that they have sent it via WhatsApp, my lord. The notice.
Why the proof of service?
My lord.
Today. And the rule says the defendant should be served. I think we may need to take another date to adopt.
As court pleases.
This case is hereby adjourned to 31st of January 2022 for the claimant to adopt the said notice of discontinuance.
As court pleases.
It is hereby ordered to be served on the defendants.
As court pleases. We are much obliged. My lord, is it virtual?
What did he say? Yeah, it's going to be virtual.
As court pleases.
Yes. Parties. Presentation of counsel. Representation of counsel.
May it please my lord?
Yes.
My name is I Salman. But my lord, I did not hear the case very well. I am for case number 5. I don't know if it's the one that is called.
You're on number 4.
Okay, sir. Okay, sir. I'm sorry, sir. I'm sorry.
Yes. No appearance from other side. Given that there is no appearance from other side, this case is hereby adjourned to 31st of January 2022. For mention here, notice shall be issued and served on the parties spoke in the case by. Next.
Case number 5. NIC/2016. And orders. And universal basic and orders.
Parties. Representation of counsel.
My Lord, I am I.S. Salman, sir.
Yes.
For the claimant, sir. We are having interference, network interference from this end. I'm sorry about that, sir.
Dauda, you said I.S. Salman?
I.S. sir. I.S. Salman.
Yes.
For the claimant, sir.
Yes.
Yes, my Lord.
Yes.
Yes, my Lord, it appears there's no representation on the part of the respondent.
Yes.
However, I have spoken to the counsel who was supposed to appear this morning, sir.
Yes.
In person of M.M. Adamu from the Ministry of Justice, Bauchi State, sir.
Yes.
My Lord, I have his instruction to once again inform the court that settlement is in progress in the matter, sir.
You said you spoke to him this morning?
Yes, I spoke with him this morning, sir, on his line.
Yes.
080.
Yes. No, just tell me what you discussed.
Oh, okay. Yes, my Lord, we have agreed that I should inform the court that settlement is in progress, sir.
Yes.
But in the light of this, sir, we shall be applying for a date.
Mr. Salman.
Yes, sir.
When last did you appear in this case?
My Lord, we appeared at the last adjourned date, just that there was some network hitches. And
hold on. I took over this case when I assumed duty at Bauchi Division, and it first came up before me on the 3rd of March 2021. Since then, there was never an appearance from either the claimant or the defendant. every time we pick this case for mention, we record absence for the parties despite the service of the hearing notices from them.
Milord, the fault.
Today,
Milord,
hold on. If today,
yes,
I did when there is no appearance, I decided to give them the last chance, in which I will strike out this matter. Because this is a 2016 matter. I don't know what we have been doing all along. You as a claimant counsel, you couldn't even appear in the matter for almost 11 or 12 months.
Milord,
And
there's
now
a mix of
that you are negotiating for settlement, and you even discussed with the council handling the matter from the defendant side, but he cannot appear in this virtual sitting, and he gave to you his words.
Milord, there's a mixed up, sir. May I seek your permission to make some clarifications?
Which kind of mix-up?
Milord, the matter has been decided already, sir. Judgment
Yes.
has been entered already, sir.
Yes.
It is the mistake of the registry that has been putting it on the course list.
Yeah.
What? Even now, the name, my lord, this is not the name that's supposed to appear.
Yes.
The name is Vermi, sir. Is Vermi is one of the heirs of the deceased persons who are seeking for their dead entitlement, sir, by virtue of the judgment of your court, sir, that made them to come to court. But the parties ought not to have been in this form. Is a mixed up, is a mistake of the registry, sir. What we have filed is an originating summons, which is different from the main case.
And
this very
they put it in
case.
the case, right? When did you file the originating summons?
So we filed the originating summons. Yes, my lord. My lord, it was filed on the 21st of October, 2024, sir. It's 21st of October, 2021.
You said you filed on the 24th of October?
Yes, sir. 21st October 2021.
Okay.
Yes, my lord.
What
My lord,
is the suit number?
My lord.
What is the suit number?
My lord, we have approached the registry. I have told them that there is a mix-up because they are still maintaining that suit number. And I have told them, I have talked to them. I have told them that this is entirely different from the previous one.
Who is this officer? Who did you meet at the registry specifically? Who is this?
You know, this, is it come? I think it's one. I've forgotten his name. I think it's Kamal.
Kamal or Kamilu?
Kamilu, sir. It's Mr. Kamilu, sir.
It's okay.
I think it's just an oversight on his part. I think in the course of their.
The originator summons is in the case file.
My lord, in any event, sir, may I, if my lord will permit me, suggest that while we are adjourning for the report of settlement, I will liaise with the registry to ensure that the papers have been put correctly, sir.
Can we have silence, please? Can we have silence, please? Can you mute everyone, please, except the person? Mr. Salman.
Yes, my lord.
It appears there is a serious mix-up with this matter.
Yes, there is, sir.
This is not the only case I noticed. There was another one.
Okay, yes, my lord. Yes, my lord.
One is for us to deal with internally.
Yes, my lord.
In the meantime, we'll have to make sure that the register is slightly amended to reflect that this is being smashed up. Yes.
Yes, my lord.
Proper parties.
Yes, my lord. Yes, my lord.
Sorry for that. In the
No problem,
circumstance,
my lord.
can you suggest a date to report settlement?
Yes, my lord. May we suggest the 8th of February, sir?
We may likely not be sitting because we have an official engagement.
Okay, my lord. Okay, my lord. My lord, any date further, any further date, sir, that is convenient to the court.
Let me give you 9th of March.
As God pleases. We are most obliged, sir.
Can we have silence, please? When the circumstances, this case is hereby adjourned to 9th of March 2022 for court of settlement. The other notice will be served on the defendant.
As God pleases. We are most obliged, sir. Thank you so much, sir. We wish you well, sir.
Next.
May please is honorable court.
I was driving to go and another.
Parties. Representation of counsel. Representation of counsel. This case is hereby adjourned to 31st of January 2022 for mention virtually. The other notice shall be issued and served on the parties. 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 This case is hereby adjourned to 9th of March 2022 for mention hearing notice will be issued and served on the parties. Yes.
Education, technical supporters, and other. Number 8, NICN/BA/21/2020 between Ali Umar Nafa and Federal College of Education, Technical, Photo School, and another.
Parties. Representation of council.
With humility and respect, my lord, I am
Yes.
H.I. Badon. I appear for the claimant.
Yes. Yes.
Please, my
Yes.
lord. Abubakar Salisu.
Pardon?
May it please, my lord. Abubakar Salisu is my name.
Abubakar.
Salisu.
Yes.
I appear for the defendant, sir.
Okay. Yes. Pardon?
My lord, at the last adjourned date, this honorable court directed that we shall comply with the order of this honorable court to go
Yes.
and file notice of discontinuance. And we have equally filed the notice of discontinuance dated the 10th day of January 2022, and we have served the defendant with the notice.
When did you file?
We have filed the motion on the notice on the 10th day of January 2022, my lord. And we have served the defendant.
Yes.
Yes, my lord, we have been served.
As given that the claimant has expressed his desire to discontinue this suit against the defendants, and parties have already joined issues, consequent upon which the claimant filed notice of discontinuance on the 10th of January 2022, which notice was served on the defendant's hearing. The claimant's case against the defendant is hereby dismissed. Make no.
We are grateful, my lord.
Thank you very much.
We are grateful, my lord.
Number 9.
Parties, representation of counsel. Representation of counsel. This case is hereby adjourned to 31st of January 2050. I mean, for report of settlement, which way?
Ask God, please.
Notice will be issued and served on the parties.
Ask God, please.
Next.
That's number 10. BA/2015. Umar Abdullahi Gabari and Ministry of Animal Resources and Nomadic Resettlement and Civil Service Commissioner.
We have more than one dependent between, say, one Ministry of Animal Resources and Nomadic Settlement, then two Civil Service Commission. If you are reading it as if they are the same dependent, they are just one. There is just one dependent. Yes, parties. The presentation of council. Yes.
May please, my lord. May please, my lord. Sorry, my lord.
Yes.
Chineye GN for the judgment creditor applicant.
Chineye.
Chineye GN.
Yes.
For the judgment creditor applicant.
Yes.
Yes, my lord. There is a pending ex parte application before you.
Yes.
The motion is dated 14th June 2021.
Council.
My lord.
What is the matter for? What is the application? Can you summarize? Can you maybe give the background parts of the application?
Is for order of degree 90, my lord. Garniship proceeding, order of degree 90.
Okay. Can you expatiate, please?
Well, my lord, the judgment creditor.
When was the judgment due?
The judgment was delivered on it was delivered on November, 3rd November 2020, my lord. I said you unmute me. Hello, my lord.
Yes, I'm with you.
I said the judgment was delivered on 3rd November 2020.
Okay.
And after the judgment, my lord, we served them with demand notice.
Okay.
To compile and pay the judgment creditor.
Okay.
But they failed to do so, my lord. That is why we filed garniship proceeding.
Well, let me take the application.
As court pleases. I say unmute me here so that I'll use that one.
Recording in progress.
You may proceed.
Yes, my lord. Yes, my lord. The motion is dated 14th June 2021. And filed on 15th June 2021.
Hold on. 14th June.
Yeah, it was dated 14th June and filed on 16th June 2021.
I should have two applications. Okay.
Yes, my lord, the motion is praying for the following orders.
Okay.
An order of degree 90, attaching the money of the judgment debtors kept in the custody of the garnishee to satisfy the total judgment debt of 21,866,479 naira 70 kobo.
Yes.
An order directing the garnishee to immediately discharge or deduct the said judgment debt of the said amount only kept in the judgment debtors or respondent account with the first garnishee account number 50 300 191 393. Sorry, my lord. Second garnishee account. Yes, my lord.
Yes.
Second garnishee account number 102 089 5687.
Yes.
And the third garnishee number 175 10 87 187.
Yes.
The fourth garnishee number 101 20 88 237.
Yes.
Fifth garnishee number 00000
Yes.
46 8980. In the name
Yes.
of Bauchi State government.
Yes.
And to immediately pay the same to the judgment creditors solicitors account number
Yes.
00 44 58 56 70 GTB account, my lord. And for such further orders, omnibus grant. The motion is supported. The motion is supported by 14 paragraph affidavit deposed by the judgment creditor himself. Accompanying the affidavit, my lord, is 2 annexures marked as Exhibit A and B.
Yes.
And a written address, my lord, dated 14th June 2021. My lord, we rely on all the paragraphs of the affidavit and the annexures therein, and urge my lord to grant our application. Most obliged, my lord.
This is what we said. That of any.
Can we have silence, please? Yes. I have carefully examined the judgment creditors expertise application. The application is requesting this court to attach the total sum of 21,866,479 naira 70 kobo, being the judgment date, being a judgment debt. The application did not give the suit number in which the said judgment was given. Even paragraph 2 of the affidavit in support of the expertise application has not provided such details. Exhibit A attached to the affidavit in support of the application is the judgment of this court, which the judgment creditor is seeking to enforce in this suit. The judgment was delivered by my learned brother K.I. Amadiji as his then was. The judgment is to the effect that the defendant's judgment debtors shall pay to the claimant all his salaries, allowances, and increments from 20th of December 2011 till the date of the judgment, i.e. November 3rd, 2020, and to pay the cost of 300,000 naira to the judgment creditor. The judgment creditor has failed to depose to facts showing how he arrives at the said figure mentioned at at prayer 1 of the application in his affidavit in support of the application. For this reason, I find no merit in the said application and same is hereby dismissed. On the last case.
Hello? They call the last case. What,
Yes,
what did he did not he did
yes, cancel. Let's call the next case. Parties. Where the parties absent. Presentation of counsel.
May it please my lord. I'm
Yes.
Hetai Barrow.
Okay.
I humbly announce appearance for the claimant applicant, my lord.
Okay. Yes.
Can my lord be pleased?
Yes.
M.K. Al-Hassan is my name.
Yes.
My appearance is for the defendant respondent.
Okay. Yes.
My lord, this matter was slated to today for hearing of our application.
Yes.
And we are ready, my lord, having been served with the respondent's counter affidavit today. But all the same, we are ready, my lord.
Yes, Mr. Al-Hassan.
Yes, my lord.
Are you ready?
Yes, we are. We are ready, sir.
You may proceed.
Yes, my lord, before you is a motion on notice dated and filed on the 13th day of January 2022. Motion dated the 13th day of January 2022, my lord, and filed the same date.
Yes.
My lord, the motion is brought pursuant to Order 17, Rule 1 of the NIC rules,
Yes.
2017, and under the inherent jurisdiction of this honorable court.
Yes.
My lord, the motion is praying for the following reliefs. One,
Yes.
an order
Yes.
of interlocutory injunction
Yes.
restraining the defendant not to tamper with the intent and terms of the Union Bank staff personal loan advanced to the claimant applicant by the respondent pending
Yes.
the hearing and determination of this suit.
Yes.
My lord, the second prayer is praying this honorable court for an order restraining the defendant from charging the claimant stroke applicant's debit balance on the staff loan advanced to him by the defendant based on the prevailing commercial rate, which is absolutely contrary to the intent and terms of the loan contract agreement duly executed between parties, pending the hearing and determination of this suit. My Lord, the third prayer is an omnibus prayer.
Yes.
My Lord, we set out the ground upon which the application is brought,
Yes.
and in compliance with the rules of this honorable court, the motion is supported by 8-paragraph affidavit with 2 annexes dated the 13th day
Yes.
of, we humbly adopt them as our deposition in support of the application, and in compliance still, my Lord, with the rules of this honorable court, we have accompanied the motion with a written address dated the 13th day of January 2022. We adopt the said address as our oral argument in support of this application.
Yes.
My Lord, by way of little explanation, sir.
Yes.
This motion was on the 13th day of January 2022, yes. And that by the rules of this honorable court, as contained in order 17, rule 1, sub 10, my Lord.
Yes.
The defendant respondent is mandated to file their counter affidavit, if any, within 7 days. My Lord, the respondent was unable to file anything, and no leave of this honorable court was sought and obtained. They only filed their counter affidavit dated 24th day of January 2022 today, and they served us with the said motion. No leave of this honorable court was sought, my Lord. And my Lord, on the authority of Nabore Properties Limited by Sis Peace Koba Nigeria Limited, decided by the 2015 to Nigerian Weekly Law Report, part 1444. My Lord, the leave of this honorable court is sacrosanct for the defendant to regularize their process.
Okay.
Yes, my Lord. In view of the above, my Lord, we urge you to declare that the defendant respondent did not file anything in opposition to our motion duly filed and served on the defendant, and to grant our applications as prayed. We are grateful, sir.
Yes. Mr. Al-Hassan.
Yes, my Lord. Having received the motion of the claimant, my Lord, we equally file a counter affidavit to his motion dated 13th day of January. We file a 5-paragraph affidavit, my Lord.
Yes.
Deposed by one Biliamino Harun. Biliamino Haruna, secretary to the YB and Kirfi.
Yes.
Yes, my Lord. In compliance with the practice direction of this honorable court, we equally file a written address.
Yes.
Dated 21st day of January 2022. My Lord.
When did you file the counter?
We file today, my Lord, being 24th day of January.
Yes.
Yes, we adopt same as our oral submission before you, my lord.
Yeah, okay.
We urge you to refuse their application, my lord.
Okay.
Thank you, my lord.
What is your reaction to
My lord.
the submissions made by the learned counsel to the claimant applicant while adumbrating?
Yes, my lord.
Yes.
That's the position, my lord. Certainly, we are out of time. It is now that I realize that we did not come along with our motion for extension of time, my lord.
Yes. Yes.
Yes, my lord.
So do you admit that you are out of time and
as course pleases, as course pleases, my lord.
And you don't have anything to tell the court?
My lord.
Don't you have the rules?
I don't have the rules here with me. That's why I was confused, my lord. I don't have the rule here with me. I could have made this necessary application to regularize our process, my lord.
We are past that stage.
As court pleases.
As court pleases, my lord.
You said you were ready. You dragged us into taking the application.
As court
you should
pleases.
have told the court that, my lord, I'm not ready. Let me seek for an adjournment to regularize my process, which process were filed out of time.
As court pleases, my lord.
Graciously granted the application.
As court pleases.
However, in the interest of justice,
as court pleases,
this court is a court of equity.
As court pleases.
It will not shoot out the respondent who has filed counter affidavit, even though out of time.
As court pleases.
As court pleases.
We can condone the non-compliance.
As court pleases. As court pleases.
The first time.
As court pleases.
Yes.
You cannot say you are grateful.
We are grateful. We are grateful, my lord.
Okay, you're welcome.
Thank you, sir. Yes.
Yes, Anand Council.
Yes, my lord.
Sorry for for the unexplained absence of the vote from the proceedings.
Escort, please.
Escort, please.
Escort.
We apologize for that. I'm making my ruling now, please. Yes,
Escort, please.
Like any bench ruling.
silence, please.
Escort, please.
Yes.
Yes, my lord.
Yes, my lord.
I have carefully examined the claimant's application for interlocutory injunction and the response made by the dependent respondent in the counter affidavit and the written address in support. I shall start off with the submissions of the learned counsel to the claimant applicant to the effect that the dependent respondent's reaction to the said application was filed out of time and therefore in violation of the rules of this court. The dependent respondents counsel too has conceded to this submission. However, this court, being a court of equity, is enjoined by the rules established, by its rules of procedure, particularly 5.3 of the National Industrial Code Civil Procedure Rules 2017, to direct departure from the rules where the interest of justice so demands. By order, these courts may upon good caution condone non-compliance with any period prescribed by these rules. This, I think, is one of the instances where the departure from the rules can be directed, and it is also one of the instances where non-compliance with the prescribed period made by the rules can be condoned.
As court, please.
The defendant respondents to file its response to the claimant's application within time is accordingly hereby condoned.
As court pleases.
Turning to the merit of the claimant's application, upon examination of the said application, I realized that the said application forms part of the reliefs being claimed by the claimant in the main suit at paragraph 54E of the statement of facts. It is the law that courts are not allowed to speak or determine a substantive aspect, an aspect of the substantive suit at interlocutory stage. I refer to the case of Ehindero against Federal Republic of Nigeria and FBN International Bank Limited versus Imanu Citations of Light. For this reason, I shall refrain from considering the merit of this application. I, however, need to give directions to the parties not to do anything that will foist a fait accompli on this court. Accordingly, parties are directed to maintain the status quo pending the hearing and determination of the substantive suit.
As court pleases.
As court pleases.
We are most grateful, sir.
Yes.
My Lord, we are grateful. However, my Lord, sir, the counsel for the defendant respondent ought to admonish his client.
Mr. Barrow.
Yes, my Lord. Particularly to the ruling.
Counsel.
Sorry, sir.
Is clear. Parties are to maintain status quo.
As court pleases.
Yes,
as court
my
pleases.
Yes.
As court pleases.
Nobody should do anything.
As court pleases.
In the direction.
As court pleases. As court pleases. As court pleases.
Mr. Alasan.
Sir.
Tell your counsel, your client to leave the loan as it were.
As court pleases. As court pleases.
Determination of this suit.
As court pleases.
The suit, if at the end of the suit, it turns out that the loan given should be charged at commercial rate, so we can make the appropriate order.
As court pleases. As court pleases.
It turns out that it should be left at the official rate as earlier given, and so be it. So
as court pleases. As court pleases.
Ask the defendant not to convert that loan to commercial.
As court pleases.
As court pleases.
We will do that, my lord. Thank you.
We are grateful, sir.
Yes. Mr. Barrow?
Yes, my lord. Subject to the convenience of this honorable court, we apply to return on the 15th day of February, my lord, 2022, if it is convenient.
What?
For hearing, my lord.
We can't get the date in February, maybe March.
As court pleases.
As court pleases.
Sir, we suggest 3rd day of March, if it is convenient, my lord.
Okay.
3rd day of March.
Mr. Alasan, do you concede?
Yes, we concede. It's convenient to us.
With the consent of learned counsel, this case is hereby adjourned to 3rd of March 2022 trial.
As court pleases.
As court please.
We are most grateful, sir.
We are grateful, my lord.
That's all for today.
May I please,
yes, my lord.
May I please, this honorable court? May I please, this honorable court? I don't know if I can be heard. May it please Honorable Court. Hello?
Idiot has raised.
Mr. Lassa,
Oga,
Mr. Lassa,
Oga,
kaji yadda ta kaya.
na
Ka
ji
yi wa
sa.
mutanen ka magana.
Zan jan faɗa wa Oga dai
Kasan
ka san.
already,
Eh,
kasan already suna charging ɗinsa a commercial rate na.
ni ka san ban san wannan ba, a yanzu na je zan masa bayani insha Allah.
To ka faɗa masa specifically abin da my lord ya faɗa.
Eh, zan faɗa
kuma
masa.
kira ka.
Insha Allah.